taken away, and so on. And I thought, I want to see whether that is in fact the case. And Mr. President, the Charter of Fundamental Rights is a useful place to start, because Section 16 of that Act, you see what I mean? But you still have to hold it though, because I never hear. Yes.
But he's not the only one who is subject to repetition, so you can go ahead.
But I want to read, if Senator Sinclair has read it before, yes, I'm grateful.
You didn't understand when you read it.
Oh, you did. But it says, Mr. President, no person who shows that he has been tried by any competent court for a criminal offense and either convicted or acquitted shall again be tried for that offense or for any other criminal offense of which he could have been convicted at the trial for that offense. And if it stopped there, then I think there would be an argument to those who opposed the two bills. He goes on, save upon the order of a superior court made in the course of an appeal proceedings relating to the conviction or acquittal. In other words, that's a Charter of Rights. And the human rights provisions that existed prior to this was in the same terms. In other words, the framers of our Constitution contemplated that in criminal matters, the Crown or the prosecution is entitled to an appeal, just like the accused person. So when it is said, Mr. President, you are taking away rights, it's not true, because the very constitutional framework permitted, Mr. President, an appeal by the prosecution. It's not me says so, Mr. President, that's what it says on a plain reading of the document. But while I sat there, I saw and was sent to me, that's the beauty of this internet, a case, I think, from the Caribbean Court of Justice. And I believe at paragraph 15 of that case, it will be very useful, Mr. President, to look at it. And it says, it is, and this is a case...
Give us a citation, please.
No, this one, not the Boyce one, but I'll tell you if it is. It probably is, but I'll tell you. Yes, this is the Boyce case. Yes. The Boyce case. Privy Council. And this is from 2006, UK PC 1, the state against Boyce. Because Trinidad is one of our CARICOM partners that has introduced in some way or the other the right to appeal. The Privy Council had this comment. It is therefore not sufficient that the law at the time of the Constitution gave one a right to be immune from further prosecution after an acquittal by a jury. Section 4 entrenched only fundamental human rights and freedoms, and the question is therefore whether the old common law rule, which prevented prosecution from appealing against an acquittal, formed part of the due process in the narrow sense as a fundamental right or freedom. Their lordships do not think that it did. They would accept that the broad principle that a person who has been finally convicted or acquitted in proceedings which have run their course should not be liable to be tried again for the same offense is a fundamental principle of fairness. It is recognized as such in many constitutions, and those constitutions are mentioned, including, and of course, there's mention of the various conventions and that sort of thing, as well as the international instruments which their lordships have mentioned. Although their lordships would accept the contents of human rights are not necessarily the same in every country, their lordships see no reason why Trinidad and Tobago should regard the common law rule as more fundamentally entrenched than it is by neighboring states which share its common law heritage. There is nothing particularly unfair or unjust about a statutory rule which enables an appellate court to correct an error of law by which an accused person was wrongly discharged or acquitted, and order that the question of his guilt or innocence be properly determined in accordance to law. So what I'm saying, Mr. President, that the argument that somehow or the other that the bills are unconstitutional, they are depriving the accused person of, and it is, as I remind my colleague, Senator Motley, that I wasn't here when everybody was speaking. I'm addressing some of the arguments that I have heard, and it may well address some that were made here. But it is certainly not unconstitutional. The Constitution expressly allows an appeal in the case of a situation where the accused person has been acquitted. And then we have signed a number of conventions. Article 14(7) of the International Covenants on Civil and Political Rights, Mr. President, for example, states in part, no one shall be liable to be tried or punished again for an offense for which he has already been finally convicted or acquitted, in accordance with the law and penal procedure of each country. And similar provisions are found in the American Convention on Human Rights. Jamaica is a party to these. Mr. President, the interpretation that has been put on these convention provisions, for example, the General Comment number 32 of the United Nations Human Rights Committee, that's the body responsible for the implementation of the earlier convention I mentioned, at paragraph 32 stated that the prohibition of Article 14, paragraph 7 is not at issue if a higher court quashes a conviction and orders a retrial. And so then, Mr. President, that Jamaica is not in breach of its constitutional provisions, and neither is it in breach of its treaty obligations. Yes? Several countries, Mr. President. I just laying the foundation, it's all right. Yes. Several countries, Mr. President, have already enacted appeals with respect to acquittals in one form or the other. I'm not talking about non-common law countries, because the civil law countries, Mr. President, never had a problem with this at all. In the civil law countries, like France and whether the Netherlands and so on, they always had a system where they had a right of appeal, and their right of appeal took the form of an entire review with witnesses and everything, Mr. President. So the civil law countries never had a problem with this issue. However, many of our Commonwealth colleagues and friends, Singapore, for example, prosecution may appeal against the acquittal of an accused person, a question of fact or law, mixed fact or law. Similarly, Mr. President, in Nigeria, yes, and several CARICOM countries, Mr. President, it has been enacted and permitted, including the Trinidad and Tobago, as I have mentioned. And many of these countries have similar socio-economic conditions and criminal crime and criminal issues as Jamaica, Mr. President. And in Africa, of course, I mentioned Nigeria, Botswana, Kenya, Namibia, Zambia, Uganda, and South Africa. South Africa, Mr. President, is often upheld as one of the countries that have one of the finest constitutions that the world has, particularly as it is in support of rights. India and Pakistan, similarly Malaysia, Papua New Guinea, and Bangladesh. Bangladesh, that's the pronunciation, I believe. And of course, as I said, several CARICOM countries have the same position. And so then, if it is that it is constitutional, the double jeopardy rule is not an absolute rule. Yes? It is subject to an appeal. Then, if we contemplate doing this, the argument that we are taking away rights would be unmeritorious. That we are trampling rights would be unmeritorious. And so that the question then has to be, why should we put in a limited way the possibility of appeals against acquittal? You see, as they used to say, and they still say, one hand can't clap. In that society, justice is to be given to the accused, and justice is to be given to the victims. It can't be one way. Some of the most egregious errors have happened where men, particularly, have been, in fact, released in circumstances where they ought not to be. And those who suffered found that they do not have any comfort or any provisions to deal with their situation. Can that be right, Mr. President? Is it only the accused that we have a responsibility to? As a lawyer who might do defense work, that is a matter that I would wish to keep as it is. But as a legislator, thinking about the society as a whole, do I limit my position to the accused only, or do I take into account the rest of the society and balance the thing? And I end, Mr. President, my short presentation by
What did you say?
Well, I can start reading the cases then. We might have to pick it up another time, another place. Yes. Yes, he has become quite an entertainer. Nonetheless, but the topics are not as, upright as this, unfortunately. But anyhow, the case from the Caribbean Court of Justice arising from Belize, Mr. President, the Queen against Flowers, and that is 2020 CCJ 16 AJ BZ. The question arose as to whether in murder cases tried by judge alone, because the Parliament in Belize removed jury trials in murder, and then they wanted to introduce appeals for acquittal in such cases, and that was challenged, and the court dismissed the challenge, upheld the right to appeal in such circumstances, and much of the same arguments I'm putting today, that the Constitution of Belize permitted it, double jeopardy is not without exceptions, and that the justice to be done to all must be paramount in these circumstances. And so, Mr. Justice Anderson, who delivered the main judgment, I just want to read to you two paragraphs. The first is paragraph 53. The court has given anxious consideration to the suggestion that the right of appeal by the prosecution of acquittals in judge-alone trials could lead to multiple retrials of an accused person until perhaps a conviction is secured. This might be a theoretical possibility, but we are not convinced there is any real likelihood that this will happen in practice because of the numerous safeguards that have been built into the system. These safeguards reflect the protection which the court highlights in the Queen against Hiles and Williams as necessary to ensure compatibility with the constitutional rights of the accused person. And then I take you to 55. The criminal justice system is intended to ensure that all parties are treated fairly. This means that an accused person must not be unduly harassed by multiple trials for the same offense through the avenue of a right in the prosecution to appeal an acquittal. This is especially important because of the usual disparity in the resources available to the private person as compared with those available to the state, and resonates with the rule against double jeopardy. At this same time, fairness to the prosecution and to the public, which the prosecution represents, must also mean the availability of redress to correct an egregious error that results in an acquittal. The availability of redress is intended to prevent a miscarriage of justice. And so, from my point of view, I accept, Mr. President, that it is not a thing that we are used to in Jamaica. But I accept that it is more than possible for errors to be made an acquittal, which renders it unjust to those who suffer at the hands of criminals. And I believe that a proper system put in place whereby it can be reviewed, Mr. President, by a competent superior court is valuable, Mr. President, and protects the citizen and hold the scales of justice even. Yeah, that's what the CCJ. The competent superior court, in our case, the Court of Appeal, CCJ, Privy Council, you name it. Mr. President, appeals are done all the time to the Court of Appeal and for other courts. And in those circumstances, nobody argues that there's a lack of trust in the judiciary. But while Senator Brown was making that point, I heard somebody sort of also says something to the effect concerning the courts and so on. But the fact is, I point out to you, Mr. President, that we do it all the time. People in civil matters or in criminal matters where they are convicted, sometimes counsel is so convinced of the innocence of his client, Mr. President, that right there before the magistrate, they jump up and they announce that I'm going to take this on appeal. Even if they don't have to announce it, and it means that they have to file paper, but sometimes they are so indignant. And many times, on appeal, the decision of the judge or the jury is reversed. That's not a lack of faith and trust and confidence in the judge, but as somebody sort of also says, they are humans, they can make errors, it should be open to review. And you notice in the bill that we have, Mr. President, it's not just open-ended. There are some countries on a point of law and a point of mixed law and so on, miscarriage of justice, you can just appeal just like the accused person or the convicted person can appeal. This is not so. There are limited circumstances. It requires, in certain circumstances, an application for leave. And even when the court sees that there is some error, it doesn't follow that they're going to order a retrial. They have the discretion what is the appropriate remedy to keep the balance of justice even. I know that there is some economic issues that we have to deal with, but I think, Mr. President, on balance, with the safeguards that we have, it is important for the purpose of justice, for the benefit of the people of Jamaica, that this bill be passed. I urge my colleagues to reconsider their position and support a constitutional and just piece of legislation. Thank you, sir.
Thank you. Thank you, Senator Graham. Minister, I think you can go ahead.
Thank you, Mr. President. Mr. President, I just want to say how much I very much appreciate the presentation made by Senator Graham. I regret that I wasn't present for all of it, but certainly his depth of knowledge, his clarity of expression never fails to impress and to settle outstanding issues in the minds of people. So I want to thank him for his presentation in particular, although I thank all colleagues for their contributions to this bill. I just want to touch on some of the issues in closing, Mr. President, because we had started with the question being asked by more than one presenter on the other side as to the necessity for the bills, a question as to why and why now, and an assertion that there's no data to justify bills which seek to grant the rights being granted under this bill or these bills. And I just want to reaffirm, Mr. President, that while database decision-making is certainly always the best, this is not the only way in which sound decisions can be made. And it is quite clear Jamaica is a country which doesn't gather all the data we require in respect of everything. And certainly, even the cabinet of the former Prime Minister, Portia Simpson Miller, had recognized that there was sufficient understanding of the circumstances in which our justice system functions, that the granting of a limited right of appeal to the prosecution was appropriate. So this discussion, this decision, this recognition that it is needed in the balance of justice, as just pointed out once more by Senator Graham, is recognized across administrations. And in fact, was even acknowledged by the leader of the opposition in his presentation in the other place, in his open remarks, that this is why he, as Minister of Justice, supported and brought 2 cabinet decisions to the then cabinet as Minister of Justice for consideration. So just to say that this matter is not a new one, just to reiterate for the record, and there is no sort of magic in the timing that's happening right now. We need to deal with the different aspects of the puzzles, the puzzle of crime that confronts us. So while we do address the matters of increased use of forensic, as we have continued to do, the establishment of the relevant labs, the database, the provision of training to our detectives and to all the technicians who are needed to ensure that the forensic lab operates well, our ability to grant greater mobility and capacity to our police force and our investigative forces, the rolling out of Jamaica Eye and the cameras, all of that is working on the side of apprehension and certainty of apprehension. But it's not the only aspect. So we have to deal with the different pieces of the puzzle, and this one is on the side of the justice system, and it is on the side of giving the victims a voice through the state. And as Senator Briam most correctly said in his closing words, certainly when we look at the society, when we ask of the society and we ask of the state, must it be that the state only has an obligation to the accused? Do we not have obligations as well to the rest of society and to the victims? The answer is certainly yes, Mr. President. We do owe it to our victims to ensure that where errors are made, and that where new evidence presents itself, and where there are administration of justice offences, that the prosecution must have the right of appeal. I want to recognize again that even where there were, as much as there are differing views and perspectives on this matter, that is normal. That's a part of change. It's a part of democracy. One doesn't expect that everyone will rally around every decision, unless so when fundamental change is at hand. And I just want to say that the fact that there is no joint select committee does not at all mean that there has not been broad consultation under this bill. Consultation has crossed administrations, it has crossed the floor. The Bar Association, after consultations with them, made a full multi-paged submission. Some of those changes have been taken into consideration even before it was tabled in the lower house, and even then more submissions came from the defense bar, which were put into the bill in the lower house. So it's important to recognize that every bill will not have a joint select committee, and that does not prejudice the function of both houses of parliament to deliver balanced bills in the interest of peace and good governance of Jamaica. It's our role. And it does not mean that you have to have a joint select committee at every point. Good, solid and wide consultation was had on both bills, and changes were made as a result. And thus we find ourselves here with the best effort at a balanced bill. Senator Briam, you had said you weren't sure whether persons had spoken to questioning the view of the judiciary. And it was very much stated earlier in the presentations from the other side. And there was even the suggestion that the bills are encroaching on the separation of powers. And maybe this is a sort of desperate effort to create a divide between the government and the judiciary by saying that they are being questioned and their capacity is being questioned. So, but I would say, Mr. President, that it's quite recognized, quite easily recognized, that judges can err. They are human. And in fact, I would be very afraid of the judge, or any person indeed, who thought or asserted that they will never make an error. Humanity is fallible, and that's a reality. And there's nothing wrong with it, which is why appeals are a part of the system. Appeals are a part of the system, and appeals question verdicts and decisions of the judiciary. So to say that because the right is now that of the prosecution, it is going against the judiciary is way off the mark, way off the mark. I also want to say that I think that the fact that the Chief Justice himself is on record as saying that the time had come from even as far back as 2018, I recall it being reported that time has come for a limited right of appeal to be granted to the prosecutorial arm. That I think that even his recognition must put paid to this argument that somehow to give the prosecution a right, a limited right even, is encroaching on the principle of separations of powers. It is that the times change and we must change our systems to ensure that we're remaining fit for purpose and delivering justice to the whole of society. And furthermore, the very same judges, when you speak to them about issues that may exist in respect of judgments, etc., say that their role is to apply the law, it is to interpret the law, and if therefore there is a sense that the law is not sound, it falls to the legislature and to the legislators, and that is our role, to change it, and that is the responsibility that falls to us today. On the matter of compelling evidence, new and compelling evidence, again, elements which were a part of the bill approved under the cabinet led by former Prime Minister Simpson Miller. Those and carried forward into this. There was a question raised as to why the point on admissibility had to be mentioned in the bill. And the fact is that, there have been rulings in the courts overseas that have recognized, that is in jurisdictions where they have adjusted their law to grant the right of appeal, that new evidence, that evidence that has been rendered inadmissible at trial can be considered new evidence in certain circumstances, where it is a finding of the court that the evidence was wrongly excluded on a basis other than its probative value, etc., which are, as was pointed out, appropriate considerations, that it can be inserted at the point of appeal once the court accepts it. And so there's a particular UK Court of Appeal case which found that evidence to which was now available to be used, but which was not used, may also constitute new evidence. And DNA match evidence was now available, but was wrongly ruled as inadmissible by the trial judge, and therefore not considered by the jury. And on the application to the Court of Appeal to permit a retrial, the new evidence was admitted. It was found that in the interest of justice and under the interest of justice requirement, evidence which was not available to be heard by the jury, so available to be used but could not be used, could be considered new evidence for the purposes, and therefore it was felt that it would be better to be clear and codify that aspect of case law in the bill. On the question as to the position of persons who bring private prosecution as judicial officers, of course, that occurs as a result of their being defined as prosecutors so that they can appeal. They can be granted the right of appeal under these bills, recognizing that it would be unfortunate if just the fact that you were a private citizen eliminated you from the right to the limited rights granted under these bills. And then those persons are all considered judicial officers for the purposes of this section. If you read the chapeau, it doesn't make them judicial officers at large. It is for the interpretation of this section. And what that does is not only allow them to appeal, but it also protects them under the administration of justice offences. Those administration of justice offences can be can include actions against judicial officers. So the intimidation of the clerk, intimidation of the whoever is prosecuting, those are offences as well that can affect the administration of justice, and therefore it was felt that they should benefit from that protection as well. And it doesn't apply across the entire Act. The question was also raised as to whether bail, what was the position on bail. So as you see in the parish court bill, the existing provision in respect of bail carries over, but the matter is silent, or rather the appellate judicature bill is silent on that matter. Yes, yes. Okay. So it's addressed there, but the Appeal Judicature Act and the bill that amends the Appellate Judicature Act is silent on it. And this was, oh, well, maybe we can take that committee then. But the point is that it had been in the bill, in the original draft of the bill, and an express provision for bail on the matter of appeal, the availability of it. And the Bar Association asked that it be removed because, as far as they're concerned, on the acquittal, the person is free and should be treated accordingly, so that the matter of bail would only arise if it is that the prosecution were to now apply for bail, in which case the Bail Act and its normal provisions would apply, as there's no constraint on that in the provision, in the bill itself. I think, Mr. President, that the other issues can probably be dealt with in committee if raised, especially given the content of the discussions and the interventions that have just been provided by Senator Braham and earlier by Senator Sinclair and Senator Campbell in particular. So, Mr. President, I'm going to again ask for support of colleagues on the bills and ask for second reading. Thank you.
Thank you, Minister. The question is that the bills entitled an act to amend the Judicature Appellate Jurisdiction Act and a bill entitled an act to amend the Judicature Parish Act now be read for a second time. Those in favour? Against? The Senate will now resolve itself into a committee of the whole Senate. Sorry, go ahead, Madam Clerk.
A bill entitled an act to amend the Judicature Appellate Jurisdiction Act read a second time. And a bill entitled an act to amend the Judicature Parish Court Act read a second time.
Thank you, Madam Clerk. The Senate will now resolve itself into a committee of the whole Senate to consider the bill clause by clause. So I'm going to take the Judicature Appellate Jurisdiction Amendment Act first. Thank you. I put clause 1 of the act, of the bill. Those in favour? Aye. Against? I put clause 2. Those in favour?
Mr. Chairman, in the debate, I had asked the leader of the House, of the Senate, if in her reply she could have specified what would happen in the case of, say, 2.9, where it says, we're under this section, an appeal is brought in any case, 2.9b, for example, and C, where the court shall hear the appeal, or the court orders a retrial of the case. The retrial shall commence within 6 months. What happens if it doesn't?
In respect of the timelines, the matter falls away. There's no inherent...
So that would be the end of the matter.
It does appear so.
But it's not clear. What could we not make it, because it will come up again at the very final page 16, again where it says, where a person is to be retried, the trial court shall fix a date for the retrial being a date falling not more than 2 months after the date of the order. Now, that would be very exceptional in our system. What happens if those standards are not met? If it is that the matter falls away and that's the end of it, it gives certainty of acquittal. Could we not say some words to that effect?
There's a concern sometimes that when a bill has been through its full examination on a matter which is contentious, that there is I think that there is a difficulty when adjustments are made on the floor that seem innocuous. There's a scheme to the Act where there are essentially two parts to both bills. There is the matter of the appeals on the administration of justice offenses, where once the Court of Appeal grants the leave of appeal for administration of justice and sentencing those, then the Court of Appeal has 12 months to hear the appeal after the date the application was made. And then for points of law, it's 12 months after the date of the appeal is brought, the date that the appeal is brought. Then where the court orders a retrial from any of those applications being brought, that is those applications for leave, then the retrial must commence within 6 months from that date on which the order for retrial was made. In the second part, for new and compelling evidence, then the time limit is where the Court of Appeal rules that the matter is to be retried. And then the trial court must fix a date no later than 2 months after the date of that order. And these are the timelines that are set out in the Act, and there is no express right to expand time, and there is no express right to prohibit the expansion of time. But this is a scheme as it is. It is anticipated that the matters will end. The 6 months that was put in the lower house, there are already considerations as to how feasible will that be in operation given the backlog in the court. Are we saying that we are granting a limited right, but then stacking the deck against the prosecution actually being able to appeal? And to further tighten the screws, I think, is maybe undoing all the efforts that are being made here.
But Minister, I don't understand why you say this is a controversial matter, because we are both seeking the same thing, as that, because from what I understand, you're saying the intention is that if it isn't done within that time, then the matter would fall away.
This is my understanding of how the bill operates.
But we're making, as Senator Sinclair says, a monumental change to the system, using his word. It is definitely, a very significant change. Do we want to leave something as important as this at large, if it is our intention that we want to give some certainty to the matter, that then we should, put some
I'm going to take some technical advice, because it is also a policy position, and I'm going to ask for some express guidance on it, and we move further. But I'm not minded to tinker because of the monumental nature. It has been heavily examined across administrations, across the floor, with the private bar and the public bar. So I hesitate. That tinkering that went down below, that actually put in that time limit, has created its own issues. And I am hesitant to do anything further.
Minister, can I suggest then, I understand your care in that you don't want to inadvertently, on our feet, so to speak, make an amendment that may interfere with the broader scheme of the legislation. But what would we lose, for example, by suspending the process, giving the drafters another week to look at it and make sure that we get it right? It's not a controversial issue. I'm not trying to be difficult. We've been recognizing that, you know, there must be some certainty. At some point we must remove the sword of Damocles over the head of the accused.
You know, I am the last person to intervene in discussions. But if the legislation says it must be within 6 months, then it must be within, and shall be within 6 months. That's the end of it.
And if it doesn't happen,
and so if it doesn't,
it must fall away. If you can't say no, if the legislation says it shall be dealt with within 6 months, it cannot be dealt with within 6 months and a day. The court don't have any authority to extend that.
This is the point. It is, the law is very express. It is very clear. It is very pointed. And all of the technical heads are nodding over there in unison as if they had planned it. That is the point. That is how the bill operates. That is what the words say. And there is no hidden language anywhere else.
it just seems that we have an opportunity to tidy it up, make it
Okay, so that the
make it very clear.
Chairman, if the Parliament is unclear, you're saying...
Don't say the Parliament is unclear. You are unclear.
I'm not unclear. However, I've seen language in legislation which says shall in 21 days. And the judges have interpreted that to be administrative rather than mandatory. And if what I'm hearing, no, because sometimes judges consult the record of the Parliament. I'm hearing you to be saying, and I hope that's what the minister is saying, that 6 months is mandatory. And therefore, there can be no deviation, not an hour, not a day, not a week, not a month from the 6th. If that's what is being said, I'm fine. At least we leave here at 1. But it's quite possible that uncertainty comes from this legislation. And we need to be clear where we're going here.
Sir, may I just comment?
No, I'm sorry. You see, Senator Brown, you draw me into this thing, you know. If you say it must be heard within a specified time, I'm not seeing the source of the uncertainty. It's not saying it shall be within a specific time frame, within a particular context of a series of time limits. I don't see that there is any uncertainty of it.
The guidance I'm getting here is 6 months is 6 months. The technical team is not minded for there to be any further amendment, and it was a policy position that was agreed in the lower house, and if there is any uncertainty, then the Hansard will reflect that debate counted it as 6 months.
I'm fine with that.
And I just want to give some...
Another infrastructure that won't...
I just want to give... Within the same legislation, Leader and Senator Brown, if you're looking where they spoke to time again in respect to notice, if you notice to be given of the appeal.
What page or clause are you looking at?
That would be page 4, and we're looking at 3, where it says that they are referring to time for the notice to be given. You will notice that there it says 14 days or such longer period as the court may allow. So you don't have that in respect to the other reference to time of the 6 months. It shall be in 6 months. So obviously that was part of the consideration, and you notice that they have written it one way there. It is not written in the same way. So,
Minister,
I think
you want me to
put
the clause? Should I put the clause?
I would appreciate it, Mr. President.
Thank you very much. I put clause 2. Those in favor?
Aye.
Against? I put clause 3. Those in favor?
Aye.
Against? I put clause 4. Those in favor?
Aye.
Against? I put clause 5. Those in favor? Against? I put clause 6. Those in favor?
Just on 6, I just want to make it clear that the views expressed by the ayes doesn't meet my support. So
I'm sorry.
My silence, my not saying aye, I want it to be read as me saying nay on the bill.
But that's unique. But retroactively, you're asking that your silence be recorded as nay.
I said it when I spoke. You were one of those.
No doubt. I put
speak.
clause 6. Those in favor? Against? I put the title and enacting clause. Those in favor? Against? Ayes have it. I move on to the Judicature Parish Court Amendment Act. Just get that out here. I put clause 1. Those in favor?
I oppose this bill too, sir. So I just want that to be clear.
Senator Brown is asking that the record indicate that he is in opposition to this bill as well.
That is correct. I don't want no retroactive.
No problem. I put clause 1. Those in favor? Against? I put clause 2. Those in favor? Against? I put clause 3. Those in favor? Against? I put the title and enacting clause. Those in favor? Against? The question is that I do report the bill as having passed committee stage. That is to say, a bill entitled An Act to Amend the Judicature Appellate Jurisdiction Act passed without amendment, and a bill entitled An Act to Amend the Judicature Parish Courts Act passed without amendment. Those in favor? Against? I do report the bills have been passed committee stage, that is to say, an act to amend the Judicature Appellate Act passed without amendment, and a bill entitled An Act to Amend the Judicature Parish Courts Act passed without amendment. Minister?
Mr. President, might I ask that the bill be read a third time?
Thank you, Minister. The question is that the bills entitled An Act to Amend the Judicature Appellate Jurisdiction Act and a bill entitled An Act to Amend the Judicature Parish Courts Act be now read a third time. Madam Clerk.
A bill entitled An Act to Amend the Judicature Appellate Jurisdiction Act read a third time and passed, and a bill entitled An Act to Amend the Judicature Parish Courts Act read a third time and passed.
Thank you very much. Minister, the motion for the adjournment?
Yes, Mr. President. Mr. President, it is not intended to do any further business.
Yes,
today.
it's okay. It's okay. Thank you. On the motion of adjournment, we had, in fact, two presentations, one from Senator Sapphire Longmore in relation to Mental Health Awareness Week, and one from Fraser Binns in relation to an environmental matter, specifically the tree planting day that was observed last week. Senator Fraser Binns has indicated that she would no longer make her presentation this afternoon. That does not mean that we as a Senate cannot recognize the importance of the environment, the importance of maintaining the environment of this country, and it does not mean that we do not pay attention to the larger global environmental issues. Senator Fraser Binns participated in a tree planting program last week. In fact, across the island, several thousand trees were planted, and we commend all of those who participated in that program, including Senator Fraser Binns, who actually showed me a video of herself in high heels planting a young sapling in Clarendon. Senator, recognize Mental Health Awareness Week.
Thank you, Mr. President. I rise on the motion for adjournment to recognize Mental Health Week, and thank you for recognizing me from a seat other than my own. My electronics was having an issue there. Mr. President, we are facing Mental Health Week, and particularly Mental Health Day being celebrated on October 10th, this Sunday, at a time when mental health is on everybody's mind. The pandemic, the COVID-19 pandemic, has impacted us in ways that our mental health has become particularly paramount. And it is anticipated within our sphere of mental health care workers that we will be seeing likely the next pandemic being a mental health one. Throughout this week of activities, there will be a number of regional health authorities, the southern region, the northeastern region, the northern region, the southeastern regional health authorities, all will be spearheading different, and of course western region, will be spearheading different activities, the schedule of which is actually available, and I will here recognize the Jamaica Psychiatric Association social media pages where the schedule of activities are there. But I want to specifically highlight the effort of Mr. Andre Wellington, who is Dean of Discipline at Alston High School in Northern Clarendon, who is a patient diagnosed with schizophrenia and has submitted an article that was published in the Gleaner, basically advocating for better understanding and treatment of persons diagnosed with mental illnesses. And I celebrate his bravery and his advocacy as part of his mental health effort at this time, Mr. President. Mr. President, COVID-19 has brought on, as suggested by a study from the Northern Caribbean University, increases in substance use. We have seen from March 2020 onwards, globally, and also here in Jamaica, we have seen increased incidences of anxiety, depression. In some countries, it has even doubled. Periods when the highest rates of mental stress were reported were correlated with the intensifying COVID-19 deaths, Mr. President. And we are all, especially now, affected by the grief and loss that is associated with COVID-19. Across countries, the mental health of unemployed people and those experiencing financial insecurity are worse, especially for the general population. A trend that predates the pandemic but seems to have been accelerated in some cases. Mental health services, Mr. President, were already overstretched before 2021. But this administration, by the Ministry of Health and Wellness, has sought to respond. Their data reflects that there has been increased need and the usage of mental health services in clinics. We have seen increased uptake of telemedicine services, helplines, and Mr. President, now I must recognize the introduction of the new helpline for children and children of abuse. Dial 211. Our children are particularly vulnerable at this time, and I celebrate that we have instituted this helpline for our children, and that's 211. Mr. President, as some may know, I am the president of the Jamaica Psychiatric Association. We have been formulating responses as best we can. We have been getting so many requests for seminars and talks, and we have been doing these. Again, we post them on our social media websites, on our social media pages, sorry. But we are also going to be developing videos and posting them starting next week on our social media pages, where persons will get tips as to how to cope with varying aspects of the crisis at this time. Coming out of requests for persons who are elderly, persons who might be going under, having suicidal thoughts, especially the grief response at this time when we are not able to normally grieve and mourn the loss of persons that we lose. The JPA is seeking, because of the amount of requests, we said, you know what, let us create these videos, let us put these out there so that people can access them at any time. But Mr. President, I'm a psychiatrist, and I'm in a unique position at this time being in this position in the Senate and directly seeing some of the consequences that we're seeing within this mental health services. My personal prescription, and this is the thing of being a psychiatrist, it's not a prescription, it's not just medications, but we formulate specific treatment plans that encompass a holistic approach, Mr. President. And we take it within the medical, within the psychiatric world, we say it's the biopsychosocial and spiritual approach to solving a person's issues. But in this forum, I will say there are 4 dimensions to health that we consider: the mental, the physical, the social, and the spiritual. And at this time, Mr. President, especially during COVID-19, the physical, as we know, our exercise, keeping healthy, keeping physically fit, is beneficial. One of the great stresses that is associated with this pandemic is the unknown of if you get COVID-19. There are measures that you can do. Your diet, as I have said before, immune boosting with vitamin C, D, zinc, the turmeric and the ginger tea and the thyme tea. And let me caution here that you don't just go unwarrantedly go pick some bush and say your immune boost. Seek advice. Don't just go boil a bunch of tea because you have issues that you can have with your kidneys and your livers, and you don't want to complicate the situation. But there are safe ways. Mr. President, just earlier to yesterday, there was a publication in the journal Brain, a highly scientific journal that recognizes a genetic link between the risk for Alzheimer's disease and severe COVID-19. This was by Magulasi and Graham et al. And what it suggests and indicates is something that we should very much bear in mind, especially with the populations who are at risk of severe COVID-19 illness. Let us specifically, especially at this time, seek to vaccinate, especially our persons who are elderly. At this time that we are driving so hard with the vaccines, let us make sure that especially persons who may be inclined towards Alzheimer's disease consider focusing and making sure that our elderly relatives, our elderly persons within our care are vaccinated at this time. And I implore us to get the vaccines out to those people. Mr. President, on the social aspect of things that impacts so much on mental health, seek to establish and continue your social connections. Our social connections are our intimate partners, our families and our friends, our colleagues, and the hobbies that we seek. The virtual space, Mr. President, at this time, let us use social media for what is meant to be, to enhance social connection. And here, I am particularly going to lobby for our young persons, our young adults, our teenagers who are naturally at a stage of what we call identity versus confusion. They are especially impacted by this pandemic, and we are seeing it in our services. They are getting depressed, they're getting anxious, we're seeing increased suicidal ideations amongst these young people. And it is primarily linked to the lack of socialization. And as their caregivers, we must seek to enable them to safely navigate the virtual space. Seek to also do things, go back to the old days of playing board games and so forth, enhancing, and you can do this online too. Mr. President, when we go through trauma, and that is what the COVID-19 pandemic has basically come with, I think we're almost now considering that some persons might be traumatized by this. Trauma is not just the adverse childhood experiences, etc. It is the vicarious trauma of hearing about certain circumstances and hearing about the consequences of very dire situations. The bills that we passed earlier today is seeking to alleviate, when we see to justice being done, it is significantly contributing to reducing the traumatic effect of some of the heinous crimes within our society. But Mr. President, I practice positive psychology, and the wellness aspect of mental health. As leaders, we must seek to push for the mental well-being of people. When persons go through trauma, you have some who are negatively affected, but you also have those who go down a path of what we call post-traumatic growth. Post-traumatic growth is when you go through something so damaging to the psyche that it actually causes you to learn and to grow from it, Mr. President. And that is where we should be going as a society, as a country, Mr. President. It takes cash to care. And one of the things that we are, and let me celebrate the efforts of the administration to keep this economy on track. We have maintained our civil service. We have maintained so much that other countries have had to lose out on. Mr. Bartlett is trying to keep tourism going. It is not easy.
So on a point of order, Mr. President, is there a time limit for these speeches? Because I also see that it's becoming controversial as well. So may the Speaker recognize that time is long, and we celebrate with you Mental Health Week and the importance, but spare us.
Thank you. Senator Longmore, continue.
Thank you, Mr. President. So my post-traumatic growth is for us to seek opportunities, not just as individuals, as families, as communities, but as a nation. And I want to just throw this out there in the sense that let us look to create new industries. We are in a virtual space, Mr. President, and we have heard how data and research is needed. Let us seek to create a research industry. This is something that could drive employment. This is something that could be used in a way to enable and to give hope to persons who are significantly traumatized. Mr. President, the last aspect of spiritual health, of mental health, is spiritual health. And I strive for us to, at this time, seek to appreciate life, our relationship with others, that there are new possibilities at this time, and that there's chance for personal growth. Set your goals, set your objectives. Let us seek out the opportunities to pursue, and enabling each Jamaican that we develop an intrinsic value of self, Mr. President, and strive to make mental health equal in an unequal world. Thank you, Mr. President. No.
Thank you, Senator Sapphire Longmore. Senator Allen.
Thank you, Mr. President.
Always a pleasure to see you.
Thank you, sir.
In person.
Thank you, Mr. President and colleagues. I'll be brief considering the time. As Senator Longmore mentioned, Sunday, October 10th, is considered to be World Mental Health Day. And as we think of mental health, we must consider the realities of mental ill health. And many in our society today are faced with the inability to cope with stresses that we are facing prior to COVID and even more so since COVID. The fact is the extent to which we are all trying to balance our lives and balance the stress of the unknown, the deaths around us, and just the economic impact that COVID has had on our lives is a little too much to bear for many of us. I grew up in Montego Bay, where the stigma of the 10th floor at Cornwall Regional Hospital has caused many to go without seeking treatment and getting this necessary attention that they need and deserve. And that has caused a strain in so many ways in our society. Every October, we don the color pink for breast cancer awareness, and we do it with ease. We hope that we get to a place where we can acknowledge the fact that so many amongst us, so many of us, are dealing with mental ill health, And we must be getting to a place where we celebrate and recognize them by making it easier for us to wear whatever that color is. We must work towards green. No. We must get to a place where our legislation or policies in our workplace make it very easy and without stigma for people to seek help, so that they're not ostracized when they come out and speak to the concerns and the issues that they're working with and living with. So I commend that teacher that Senator Longmore spoke of. And as much as possible, the more we see people being able to come out in this way without being given the funny look or being considered incapable of being members of society, the better off we'll be as a nation. I therefore look forward to the day when Jamaica is truly the place that will allow people to speak freely of their mental ill health and mental uncertainties at different times, because that is the only way we are guaranteed to have the kind of place that we truly want to have families work and live and speak of in the way that we speak of Jamaica in the 2030 vision. So I celebrate with all of Jamaica and the rest of the world World Mental Health Day, and I look forward to when it's no longer stigma to say so. Thank you, Mr. President.
Thank you very much, Senator Allen. That was very informative and useful.
Mr. President, it is now truly not intended to do any further business, and I thank both contributors for their interventions on such an important national and global issue. Mr. President, might the Senate be adjourned for a date to be fixed?
Yes, but not before I also thank both presenters on the issue of mental health. It is a critical subject and one that we ought to recognize, especially as was pointed out by both speakers during this time of this COVID pandemic and the need for us as a population to encourage vaccinations at every level. I noted this morning in the newspaper that the Prime Minister had indicated that it was the hope, and I don't think it's the hope of the government. It is the hope of well-thinking Jamaicans that we can reach 1 million vaccinated by November. And I really encourage all persons, allow me just 1 minute. Many persons have been vaccinated for any number of reasons, and they are very reluctant to tell their friends and family that they are vaccinated. Every musician that leaves this country and go abroad is vaccinated, including those who go to England to celebrate concert or go to Belgium or wherever in America. Every athlete that went to the Olympic Games was vaccinated. Every one of them, including our lovely ladies who came 1, 2, 3, all of them were vaccinated. And I just wish that our people could recognize that and take examples that are in the society. Those are the few observations I make. Well, the truth about the matter is that government logistics is one thing. But this is not a matter for the government alone. This is for every Jamaican. It's not a matter for the government alone. Thank you very much for listening to me. And if I could have changed at least one mind, even one, I would have done my duty to my country. Thank you very much. The question is that this Honourable Senate be adjourned for a date to be fixed. Those in favour? Against?